Good afternoon and welcome to another episode of Lunch and Learn. And today we will be discussing how to deal with paternity disputes, specifically when it comes to maintenance matters. Yes, the old DNA test, that is what we are discussing today. So if we look at the program for today, what we will be discussing, just an overview of the program. Today we will be discussing the position of paternity tests in South Africa. Now, paternity tests has come a long way since the first original blood tests, where that could only be done when the children was a couple of months old. Nowadays, we can do that even before birth. But I'll go into that a little bit more detail later on. We will also be discussing some case law, the provisions of the Children's Act that deals specifically with paternity. We'll also be referring to parental responsibilities and rights in terms of the Children's Act, and give you a broad understanding of how blood tests, these DNA tests, work when it comes to specifically maintenance matters and paternity tests. We'll be discussing the cost involved of these tests, as well as a lengthy discussion on the respondents using these DNA tests as a means to delay maintenance payments. We will also look at the question if maintenance courts, or any courts for that matter, could force a respondent to go for a paternity test, and what would the effect be if the parties do not go for the paternity test. We will also be explaining the process of you going to the independent laboratory to go for these type of tests, what is needed, what documents are needed, what do you need to take with. And then lastly, we will be discussing the question that everybody wants to know, is that can DNA tests be manipulated, or could it be changed by and altered by drinking any form of substance or drinking muthi? We'll be going into some detail and explaining that in a couple of slides. But without further ado, just to bring it back to some logistics, if you have registered on our website, www.lunchandlearn.org.za, you would have received a link beforehand, and that link would bring you to our website. And there you could access some pre-reading material. That's material that you could read beforehand, just to give you a general overview of what will be discussed. You would obviously have the link to the live webinar, as well as, most important, the resource and templates tab. Now, in that tab there, you will find a copy of all the slides that we will be using in this webinar, as well as a complete course handout. Now, this handout has been compiled by one of my candidate attorneys, Erin O'Neill. Thank you for that. And that details all the provisions that we will be talking about, all the cases that we will be discussed during this webinar will be contained in the webinar, and that will be available for you to download at any stage. Now, yes, I see that if I just look at my dashboard, we have quite a number of attendees. Welcome to each and every one of you. On our social media, we've got social media platforms, Facebook groups. We've got about 3 Facebook groups that we stream live to. We've got 2 websites that we stream live to, LinkedIn that we stream, and a couple of other social media platforms. And I see, if I can just look at the dashboard, that yes, we have about 470 people joining us from all over South Africa. Welcome to each and everybody joining us today for this rather complex issue of how to deal with paternity tests when it comes to maintenance matters. But without further ado, let's jump right into it. So the first question that one needs to ask is, what is paternity? Now, paternity is basically what it means as fatherhood. And paternity is established when an accurate, accepted paternity test is able to demonstrate that an alleged father is the biological father. Now, we use also the same test to exclude someone that could not possibly be the father. So it's the same test that we use. Now, these tests have been evolving around time, and it's been updated to international norms and standards for a couple of years. And in the last couple of probably 30 years, we have made great strides with using the DNA sampling methods and the testing done in paternity disputes. Like I said previously, a couple of years back, we could only do paternity testing when the child was of a certain age. But nowadays, you could even do DNA testing to confirm paternity, even at a stage when the child is unborn. So there has been a lot of involvement regarding the test, the scientific tests of paternity in the last couple of years. So why is it important to know what is paternity and why, and where does it fit into the whole maintenance system? If we look at Section 6 of the Maintenance Act, and we've dealt with that extensively in previous webinars, Section 6 clearly says that complaints relating to maintenance, child maintenance, could be done in the process where any person legally liable to maintain any other person and he fails to do so, could approach the maintenance court, and the maintenance officer would then investigate the matter, bring the matter before court, so that could be adjudicated with regards to maintenance. But the operative words in terms of Section 6 is the wording, any person legally liable to maintain any other person. So one would ask the question, who is a legally liable person to maintain? Obviously, in the sense of maintenance, one would look at the father. That would be the legal liable person to maintain another person. So we need to delve a little bit further and think about what is the difference between married and unmarried fathers. Now, usually what happens in maintenance matters, about 90% of the cases that I attend to at maintenance court involves unmarried fathers, fathers that were never married to the biological mother. So in terms of the Children's Act, if one looks at parental responsibilities and rights when it comes to unmarried fathers, it is distinguished between the parental responsibilities and rights of the married father. And we'll get to that in a couple of seconds. But for now, I could just mention that unmarried fathers, fathers that have never been married to the biological mother, does not automatically have or acquire parental responsibilities and rights. They do not get that automatically. They can acquire it at a later stage, and we'll go into some more detail in a while. Very important that the presumption of paternity could only be used in terms of unmarried fathers, and we'll be discussing Section 36, which could be used very easily in maintenance situations in maintenance courts, and we'll discuss that in a couple of slides. So unmarried fathers, that is mostly the cases that we deal with in maintenance courts, and it's very often that with the unmarried father, there is a dispute regarding paternity. Turning to the other side with regards to married fathers, yes, sure, a father, if he is married, legally married to the biological mother, then he would acquire parental responsibilities and rights in terms of Section 18 and 20 of the Children's Act. And it's very seldom that these type of matters would end up in a dispute with regards to paternity, but it could be disputed. Mother could have had a wandering eye, and the child could have been conceived, and the father is unsure. The married father is unsure if that is his biological child, and then paternity would come into play. So most definitely, it is also available to married fathers as well. I've spoken and I've referred to parental responsibilities and rights. Now, those are rights that are conferred to you in terms of the Children's Act, specifically Section 18, where it says that parental responsibilities and rights is rights in respect to a children, and it includes the responsibility and the right to care for the child, to maintain contact with the child, to act as a guardian of the child, and then lastly, to contribute to the maintenance of the child. So those are the parental responsibilities and rights that both parents would have in terms of the Children's Act. And that's important to keep that in your back mind, specifically when it comes to the distinction between married and unmarried fathers. If we look at married fathers, now remember now we said that the parental responsibilities and rights include the care, the contact, to act as a guardian, as well as the payment of maintenance, like we saw in the previous slide. So when we turn to married fathers, we look at Section 20 that deals with specifically the parental responsibilities and rights with regards to married fathers. Now, a biological father of a child that is married with the biological mother has full parental responsibilities and rights. And those rights would be if he was married to the child's biological mother, or if he was married to the child's mother during the time that the child was conceived, or during the time of the birth, or any period, any stage between the child's conception and the birth of the child, then he would acquire automatic parental responsibilities and rights, and also the right to pay maintenance. If one compares that to unmarried fathers, we need to look at Section 21 of the Children's Act, where it says that, you know what, an unmarried father does not automatically get parental responsibilities and rights. But they can acquire full parental responsibilities and rights if certain things happen. And those things are if he was living with a mother in a permanent relationship or permanent partnership during the course of prior to birth. If he also, regardless if he stayed or lived with the mother, if he consents to be identified or successfully applies in terms of Section 26 to be identified as the father of the child, then he could acquire full parental responsibilities and rights. Now, in terms of our customary law, if you pay damages towards the family of the biological mother, in terms of customary law, then you would also acquire just by doing that, you would acquire full parental responsibilities and rights. The other provisions are that if the father contributes or has attempted in good faith to contribute towards the child's upbringing for a reasonable period of time, he could also acquire full parental responsibilities and rights. And then lastly, which is probably the one that's most important, if the father has contributed or attempted in good faith to contribute towards the expenses in connection with the maintenance of the child for a reasonable period, then he would also acquire full parental responsibilities and rights. Now, I want to pause just for a moment with regards to what I've just said and the parental responsibilities and rights. Now, parental responsibilities and rights has got nothing to do with the fact that a biological father has the duty, the common law duty, to pay maintenance. Parental responsibilities and rights deal with the care and the contact and the guardianship of the minor children, which a married or an unmarried father might acquire or actually receive upon birth. And that has, together with that, is the right to pay maintenance. But this does not detract from the fact that in terms of the common law, there's a common law duty of support of biological parents towards their children. That is a common law duty, and that was re-emphasized and codified in terms of Section 15 of the Maintenance Act, where it clearly says that despite any provisions of the law, the common law duty of the duty of support is enacted. So both parents, regardless if they were married or not, or do have parental responsibilities and rights, would be liable to pay maintenance proportionate to their income. So that is important, just to have a distinction between those two. So when does paternity disputes usually come to the fore? When is it usually brought up? Now, if one looks at the diagram on the screen, this is the normal process that would be followed during a maintenance inquiry, a maintenance process. And usually what happens is there might be an application, it might be a new application, it might even be an application for a variation. That goes, you fill in the necessary paperwork, you take that to the maintenance officer, and then the maintenance officer would invite the parties into their office in terms of Section 6, like I referred to previously, for an informal discussion with regards to the payment of maintenance. And that could only be if a person is legally liable to maintain another person and it's not doing so. And we're referring here now to, for example, the respondent as the father not paying maintenance. So they would come into the office of the maintenance officer, and there would be a discussion, an informal discussion, and a negotiation process and a discussion on specifically the child and the child's needs. And it is usually at that stage where the father would say, or the respondent, and usually it's the father, would say, but you know what, I dispute paternity. I do not agree. You know what, it's usually the family that he gets pressure from the family, where the family says, but you know what, the child does not look like you. Or yes, he is the father, the child looks like you. That is not scientific proof at all, but it does happen in practice, and it does happen quite often. So at that stage, the respondent would say, but you know what, I dispute paternity. I do not agree. There is no legal obligation in terms of any law for me to maintain somebody else's child, so I dispute paternity. Now, in this sense, it could also be that the father might use this as a delayed tactic. We see that very often, and now that DNA testing and DNA profiling has become so much prevalent in the news and the media, the people and the respondents out there are aware that they could use this method as a form of delaying tactic when it comes to maintenance matters, not in order to finalize the matter expeditiously. So during that period during the Section 6 inquiry, say, but I do not agree to that, or at any stage that the maintenance officer is of opinion that parental paternity might be in dispute, then there's an obligation upon the maintenance officer in terms of Section 21 of the Maintenance Act, as well as the codified instructions, the DOJ Code 26 of 2015, that the maintenance officer then act in accordance to Section 21. And Section 21 states that, and that Section 21 deals with orders relating to the scientific testing. So Section 21 refers to where the maintenance officer has at any stage during the course of the maintenance proceedings, if he is of the opinion that paternity of any of the children there is in dispute, he must then inquire from the mother and the alleged father at that stage if they are prepared to submit themselves voluntarily for the taking of blood samples in order to establish paternity. Usually what happens is that the father would request that test, and then there would be a discussion between the maintenance officer and the father with regards to the costs thereof. There's onus upon the maintenance officer to establish if the father or the mother has the means in order to pay for that. And if they do not have the means to pay for that, then the provisions of Section 21(1)(c) kicks in, and they could request the maintenance court to hold an inquiry, a financial inquiry, referred to in subsection 2. And that is dealt with where they deal with specifically who can pay for these tests, because these tests are quite expensive. Then there should be an inquiry. It would be done in court, and the court would investigate the means of the mother, her income, her expenditure, as well as the alleged father. They would look at his income and his expenses, as well as they would look at the circumstances. And the court at that stage would investigate, what has the father been paying, contributing previously for maintenance? Has he made any contributions? Has he paid for the damages in terms of customary law? And those are all the circumstances for the court to evaluate and to see who needs to pay what for the paternity test. After the court then has made this inquiry, have done this inquiry, the court may make any provisional order that they deem fit. And usually what happens is that they make an order that the father needs to pay for that, or the mother needs to pay for that, or that there's a proportion, they pay half, or whatever the case might be. Or it could also happen that if both parties do not have the funds to pay for, say, the paternity test, that the state could pay for these tests. Now, it is I've seen it in practice, and what usually happens is that in the event that not any of the parties are in the means to pay for these tests, that the state indeed fits the bill and they pay for the test. But if the test comes back positive and it is the father, then the court are well within their rights to make an order that the respondent then pays back to the state that money that was spent for the paternity test. So just be cognizant that there might be a cost implication when you ask either for a DNA test or you dispute the test. So if you're the complainant in the matter and you dispute the fact that he is the father, because he wants to go for a test and you want to be nasty about that you could land up paying for half the costs if you do not give your support and cooperation to the courts. Usually during this, like I said, it happens during the Section 6 inquiry. It could also happen during a later stage. I've had a case where it was a formal Section 10 inquiry. So the people went to the maintenance officer. They could not resolve the matter, and the matter was then transferred to court for a first application. Now, at that stage, in my case, the case that I had, the father has been contributing here and there towards maintenance. Henceforth, the complainant went to the court to get a court order, a maintenance order, and it was only at the Section 10 stage, the formal inquiry in court, that paternity was raised. At that stage, I've done arguments to court that he had been paying for a while, and that it was at very late stage, and that he had ample opportunity to dispute paternity tests prior to coming to court. He could have done that during the Section 6 inquiry, which is ultimately why we have the Section 6 inquiry, in order to investigate and to get all the information ready for the maintenance officer or the maintenance court to make an informed decision with regards to maintenance. But usually during the Section 6 inquiry, it is the father that would dispute paternity, and then the maintenance officer would explain to him that there's a cost involved. And the cost at this stage, as of today's date, was about 2,300 Rand. Now, these tests could be done through any independent labs, like Pathcare, Ampath, and so forth. There are numerous testing centers, individual or independent laboratories that could actually do these type of testings. I know that some of the universities also offer these tests, and maybe at a reduced price. The normal DNA kits that you could buy over the internet is not advisable. It is not admissible in court because there's no chain of command, there's no chain of custody that would be followed, and I'll be alluding to that in the next couple of slides. So you could use these DNA tests, these kit forms, but it would not be admissible in court. And the results of these tests usually will be available after 5 to 10 working days, and it would be made available to all parties if all parties contributed to the cost thereof. If the state paid for it, then the results will only be made available to the state. So let's come to Section 36, and I've dealt with Section 36 in previous webinars as well. And that deals with the presumption of paternity where the parties are not married and a child was born out of wedlock. So just to read and to get the statutory requirements of Section 36, Section 36 says that if in any legal proceedings in which it is necessary to prove that any particular person is the father of a child born out of wedlock, it is proof that the person had sexual intercourse with a mother of the child at the time when the child could have been conceived, that person is, in the absence of evidence to the contrary, which raises a reasonable doubt, presumed to be the biological father of that child. So what does that mean in practical terms? In practical terms, it would mean that if you go to the maintenance court and you could convince the maintenance officer and tell the maintenance officer that you had sexual intercourse, that you had an intimate sexual relationship with the respondent during that time that the child could have been conceived, then there is a presumption of paternity that kicks in. And that's actually just a mathematical calculation that could be made, because we know that it takes 9 months for a child to be born. So if you could prove that you and the complainant and the respondent had a sexual relationship during the period that the child was conceived, then the presumption of paternity could kick in, and the maintenance officer could put that in front of the court and could put that to court, that they rely on Section 36 of the Children's Act. So how would one do that in order to prove that they had a sexual relationship, or they might have had sexual intercourse during the time when the child could have been conceived? If you scroll back on your WhatsApps and you scroll back on your Facebook pages, and you could prove to the maintenance officer that during that time you were in a relationship, and you can confirm this, that you were in a sexual relationship, then you might use the provisions of Section 36. So there would be an inquiry if the applicant and the respondent then had a sexual relationship, and the court would also, and the maintenance officer would also look at external facts that creates a presumption that the father is the father of the child. Very important, and this is not being used by the maintenance officers in South Africa, is that if you rely on Section 36 of the Children's Act, that you could ask, because the matter will be postponed for obviously for the DNA test, because they would not do the DNA tests immediately. So the matter would be postponed for maybe a week, 2 weeks, depending on what the court roll looks like. So it might be postponed. And then you could ask, you as the complainant could ask, you could inquire, you could actually insist that Section 10.6 be used, and that is where an interim maintenance order be granted. So you could ask for an interim maintenance order to be made pending the finalization of these DNA tests, which might take a week or two, or even 3 weeks for the court, depending on what the court roll looks like. So if you are faced in the magistrate court with, or the maintenance court with the request for paternity, that the matter be postponed, because remember, Section 10.6 says that these postponements, if they are necessary, should be limited in duration and number. So, and then you could apply for a interim maintenance order. So that is to your advantage. Immediately, if the respondent wants to postpone, or the maintenance officer wants to postpone the matter, then ask that an interim maintenance order be granted immediately, pending the finalization thereof. So how does this paternity testing, this DNA testing work? And I'm referring to a website there. You would see that in the slides as well as the handout. So DNA analysis basically involves the direct examination of the genetic material, the genetic makeup that a child inherits from both parents. So we have DNA strings and DNA cells in our body, which are inherited from both sides, both from the mother and the fathers. Now, these DNA, this blueprint of DNA, is located throughout the whole body. It could be found in blood cells, it could be found in your skin, it could be found in saliva, it could be found in muscle, it could be found in bone and other various tissues. So that is all over. So the DNA of only a single cell is needed, because the whole blueprint of the DNA could be found in one single cell throughout the whole body. And those cells are identical. Interestingly enough, and most people do not realize that, is that a person's DNA is completely established at conception and never changes throughout their life. So you keep your set of DNA, this markers that you have on your DNA string, the helix of DNA, it never changes right throughout your life. Each and every individual's DNA is absolutely unique, just as a fingerprint is unique. The only difference is that if you are identical twins, that you would share the same DNA profile. So, in the off chance that you dispute paternity with regards to identical twins, that might pose a interesting question regarding the paternity of who might be the paternity. But there are other scientific ways to prove and disprove paternity when it comes to identical twins as well. So the only time that you would have two people having the same or identical unique DNA patterns would be when they are identical twins. So during these tests, during these paternity tests, the genetic characteristics, this genetic characteristics, or the blueprint of the child, is then firstly compared to that of the mother. So they look at the mother's DNA and they compare that with a child. And those characteristics in the child that is then not found with a mother is obviously considered to have inherited from the biological father. So if the tested man, if the alleged father, does not have that generic or genetic characteristics necessary to be the biological father, he is then excluded. This is all done scientifically, and it's done in a laboratory under very specialized clinical conditions. And if the tested man's DNA does then contain those specific genetic characteristics or the blueprint of DNA, then the probability is that man, that person tested, that man is the biological father. And then the laboratory would obviously give a report to that effect. So how accurate are these DNA tests? And that's also a question that pops up quite often. How accurate are these tests? I do not believe these tests, they give false positive and so forth. So I've been doing quite a number of research specifically on this, looking for ways and means that these tests could be manipulated, and how accurate are they. And I've read up cases where people were exposed to long-term radiation, and that changed their DNA, and after upon investigation thereof, it was actually not that the DNA was changed or altered. The DNA patterns were, the genomes were still the same, but it was mutated. But the blueprint and the markers regarding paternity could still be used. So the DNA patterns of the child, the mother, and the alleged father are compared. And if the marker patterns fit perfectly, like in little blocks, if they fit perfectly, then the probability of paternity is greater than 99.999%, and the alleged father then is proven to be the biological father. So it has sometimes happened that some of the one or two of these markers do not match 100%, and that might be to normal changes that may occur from generation to generation, or in the case where a person is exposed to long-term radiation. Then, because it's not 100% match and there's only one or two markers, then the lab would make a statistical, they would evaluate and give a statistical chance of paternity, and that is calculated in conjunction with all the other evidence. If there are 3 or more mismatches in the markers between the patterns of the child, the mother, and the alleged father, then that father is totally excluded to be the father. Are DNA reports admissible in court? Absolutely. Anyone that watches TV, social media, they would hear that DNA tests, what they, specifically in crime scenes, that they got the DNA and they tested the DNA. And yes, most definitely, DNA tests are admissible in court, and we use them quite often, specifically not only for paternity testing, but also in criminal cases where they would only need a single cell or a blood drop in order to establish DNA. We also get that in terms of sexual offenses, where we have the rape kits, where we would take samples of bodily fluids, and that could be tested for DNA in order to match if someone raped someone or something like that in terms of the Criminal Procedure Act. So yes, DNA reports are admissible in court proceedings, most definitely. There is a full chain of custody trial that is available from the sample collection, from the time that they collected it, right through to doing the test and then the reporting right at the end. And only then could it be used as evidence in court. So there needs to be a whole custody trial, a trial of custody, a chain of what happened from the get-go, from taking the blood sample, giving the consent, right through to the end. That needs to be reported as a chain, a custody trial, and then it would be admissible in court. If the integrity of the samples are damaged in any way, or if it is opened, or the seal has been broken, and in any of these tubes that the blood was drawn from, then that or even if it was tampered, then the samples would not be tested, and those results would not be given out to the parties, and they would just request the parties to come back to redo the test. Very high standards in terms of the South African legislation. There are very high standards, quality standards that needs to be adhered to and to be observed throughout the process of paternity tests. So, yeah, I do get the question, what is it possible that you could use somebody else's blood? Yes, it is possible, but then you need so many people involved in this whole chain of custody in order to make that happen, that the probability to do that is quite low. It would mean that you would have to bribe the officer taking the blood. You would need to bribe the person doing the blood test, and also the person that needs to compile the report. And that is the probability of that happening. That is very low. Does it happen in practice? I've not seen one. I've heard allegations thereof, but the proving thereof seems to be quite difficult, and we never had a successful conviction of tampering with these blood samples. What what often does happen is that the tubes might fall and it might break, and then it is considered to be contaminated blood or contaminated sample, and that would not be used, and the parties would be requested to come back. So if there's any chance of tampering, remember the names of the people are not on these little tubes. These tubes the tubes or the blood gets drawn in these test tubes, and these tubes then go to the person that tested, which is obviously a different person. So, and there's no names on it, so they would not know who the parties are. So chances are that you, amongst 1,000 of tests, to specify specifically who it is or to identify specifically who it is quite low. The risk thereof is quite low. Now we come to the question, can DNA tests be manipulated or changed by drinking any form of substance or muthi? And the answer here too is no. There is no way. Like I've said previously, your DNA is contained through each and every cell of your whole body, and you only need one cell in order to establish paternity. The DNA profiling of only one cell is needed. And usually what is done is we do it by drawing blood. And I'll explain the process in a while. But no, there is no way that the DNA results could be altered by drinking any form of substance. I've had cases in the Eastern Cape where people drink sunlight liquid mixed with beetroot juice. And I mean, you can just imagine what that intestines look like. But there is no way that you can alter, because you have DNA right through your whole body. It's enshrined in each and every cell of each and every tissue of your body. It is impossible for you to change that. I've referred to the case or the matters that I've read up on where the people were exposed long-term with radiation, and there seems to be some doubt if the DNA was changed, and they actually realized that the DNA has never changed. The blueprint of the DNA has never changed, but it has mutated. But the blueprint thereof still stayed the same. So there is no scientific proof. And I've done extensive search and extensive research on this topic. And I could find absolutely no evidence whatsoever, right through the internet or from the universities, not only from South Africa, but also abroad, of drinking or changing the DNA at any stage. The genetic profiling and the genetic altering of DNA by creating cells and so forth has been done in laboratories, but not very successfully. But for all practical purposes, in terms of the South African legislation, there is no way. So if you as the father would go out and consult with your traditional healer or your doctor, and they advise you to drink this pill or drink this muthi or whatever, that your DNA would be changed and that you would not be considered to be the father, the chances are that you are wasting your money is 100%. There is no way that DNA could be changed or could be altered or manipulated to give a specific exclusion of paternity. So what is the procedure that is needed? Usually what is done is we do a blood sample is drawn. A blood sample is required from the mother, the alleged father, and the child. A child at any stage could be tested. Traditional tests said that the children had to be at least 6 months old before they could be tested. But with the involvement of the new tests, there's no age limits to DNA, and we could actually do testing on unborn children, where they would take some of the amniotic fluid and they would do some collection there, or even from the fetus, in order to the fetus, which is still in the womb of the mother prior to birth, in order to establish paternity. So the tests have been evolved quite a lot in the last couple of years. Paternity testing can also be performed using post-mortem specimens. So even if a mother has died or father has died, and there is a way that you have some of his DNA, and like in hair follicles or blood samples or whatever the case might be, then that could be used post-mortem, even if a person died as well. We could do the DNA testing on those people. Can paternity testing be done without the blood sample of the mother, and who would need to be present? Is it possible? Statistically, practically, yes, it is possible to perform a paternity test by comparing the DNA samples from only the child and the alleged father when the mother is, for example, deceased. It is possible. One would obviously look at legal guardianship, the parental responsibilities and rights that I've mentioned, who would be able to give permission for such a test. However, it is strongly recommended that the mother is present or is included in the testing, because when all the markers of the mother, the child, and the father is compared and it is matched, then a positive paternity test result could be given. There are means and there are ways, and one thinks about the ancestral testing, where because we share DNA with our brothers and our sisters, because we are genetically linked, it is possible that we could get an affirmation that those people are related, not necessarily paternity, but that those people are related. So a blood sample from the sister could be taken and compared to the child or the father, and then at least the father, meaning if that is in dispute, to see if they are genetically related. But these tests, although they might be valid and it might give you an indication of ancestry, that they share relationships or that they share a relation with each other and that they are related, those are, although they might be valid, they are not considered to be evidence, and it could be used as a means to prove paternity. So what would happen if a person refuses to take a blood sample? In terms of Section 37 of the Act, the Children's Act, it says that if during any legal proceedings with regards to paternity, it could be either the person self or the other person or the child, and such a person then refuses to do the blood test or refusal to submit themselves for the taking of the blood, then the court would need to warn and to caution that person, to say that a negative effect might be drawn due to the refusal thereof, and it might have an influence on the credibility of that person when it comes to court. One needs to bear in mind Section 12.2 of the Constitution, where everybody has the right to bodily and psychological integrity, which also includes not to be subjected to the medical and scientific experiments without their specific informed consent. And that's very important to note, because we link that with Section 37 as well, where the court actually, or the courts recognize that you could refuse to take blood samples for paternity tests. So you have that side, that moral side on that. So the question now would be can the courts then force a person to go for paternity test? And if we look at current legislation, the LB versus YD case in 2009, and the applicant in this judgment was the father, who wished to have to establish the paternity of his child, and the mother in this instance did not want to go the DNA testing because she probably knew that the father was not the father. So she refused to undergo the DNA testing, and then she said that her rights to privacy and dignity in terms of the Constitution was infringed, and it was her constitutional right to refuse such tests, and that it would not be in the best interest of the child if such a test should be done. The court in this case said and confirmed that there was no legislative framework that specifically deals with the question of whether a respondent can be forced to go for a paternity test. And the courts also realized that, there are so many previous court decisions which was not unanimous with regards to this specific case. In this case, the court ultimately found that the courts do have the power to compel a parent to undergo a paternity testing if it was in the best interest of the child. So yes, the court can, in certain instances, if it is in the best interest of the child, force you to go for a paternity test. This was also reconfirmed in a later case, S versus L, that dealt with disputed paternity and blood tests, where a mother was refusing to allow the child to do the blood test. So the mother, as the legal guardian and having full parental responsibilities and rights, refused the child to go to get the blood test done. Now, the court then ruled on this matter in the S versus L matter, and the court said that the court has the power to consent to the blood tests on behalf of the minor child, because the court is then considered to be the upper guardian of all minor children, and these tests are in the best interest of the minor child. But that would happen only on a case-to-case basis, and you need to present evidence that it is in the best interest of the child. In this matter, the court actually overruled the mother and said that the child had to go for the DNA testing. So what documents are required by the lab? Obviously, you would need to have positive identification, have your ID. If you go to the lab for the DNA testing, you would need to have your ID document, the original one that you need to take with, your passport that you need to take with. The mother and the father, both parties need to have their ID documents. If you have a driver's license, take that with, or if you are an asylum seeker, you take your asylum seeking permit as well. The birth certificate or the clinic card of the minor child is also needed. If you do not have that available, if you do not have any proof, then you need to file an affidavit that states the reasons why you could not have that ready. But in most instances, the labs would require at least a birth certificate or a form of identification that is indeed the child that is being tested. Consent from the legal guardian needs to be given to the labs as well, because they need to give permission. They cannot just simply take the blood from somebody, because that would be infringement of Section 12(2), the right to bodily integrity in terms of the Constitution. So they cannot just take the blood from any person. They need consent to do that, to inflict some harm and to draw some blood. They need the permission thereof. The biological mother needs to consent for the blood sampling for herself as well as the minor child. And she also needs to verify that all the samples were correctly labeled. Remember now I said that the only way that you could manipulate the whole system is that the names on the vials, on the little test, the tubes, needs to be altered. So in this instance, one of the requirements are that the mother, the one that also gave blood, needs to confirm that the samples were correctly labeled. And that's usually just with a number. They would read out the number and you would repeat it back to confirm that that is indeed the correct tubes of blood that has been drawn. All individuals under the age of 16 will be considered minors. That's now in terms of the labs, and it would require consent by the legal guardian. The biological mother at all stages having full parental responsibilities and rights would be considered to be a legal guardian. An alleged father would only be considered to be the legal guardian and to sign on behalf and give permission on behalf of the child. If he provides a marriage certificate or a court order or divorce order granting him legal guardian status. In cases where another individual or a family member, like an aunt or an uncle or a grandmother, is present to sign the necessary consent, because the child might be in their custody and might be in their care, then they need to provide a court order awarding them legal guardian status of that specific child. If they cannot do that, then the matter will be referred to the family court or the family advocate for intervention, and the blood test would not be done. The alleged father is also required to sign consent for his own blood sampling, and he also needs to verify that the labels are correct. So again, there is a checks and balances. There's a control system where both parties need to check up on the other one to say, but it is the correct samples that was taken. I had a matter where the parties were not present in the same room when it happened. I had a case where the father was in George and the mother was in Kroonstad. And I organized and I arranged with the courts and I arranged with the mother and the child at Pathcare in Kroonstad, so that they do the DNA sampling and they draw the blood there in Kroonstad, and the father would go to George and at Pathcare and he would do it there. So they were at two different locations. And it worked quite well because they did the test in George for the father and in Kroonstad for the mother and for the child. And then the two labs spoke to one another and they compared the results, and they could actually establish that he was indeed the father. We relied heavily on the protocol that the labs and the trust in that the protocol of the labs would be followed. But it is possible that even if they are not in the same room immediately, that the tests could be done remotely by different labs and then compared. If the paternity test is referred to by the court and the minor child's name is stated in the referral, then no consent from the legal guardian is required. Like we saw in the previous case, S versus L, if the court overruled the mother with regards to consent, then there is no consent needed from the mother or the father because there's a court order to that effect. The mother and the alleged father will then be required to certify that the blood was drawn for the purposes of paternity testing, not for something else, and that the tubes containing the blood or the Guthrie cards were correctly labeled and identified. And that is basically, in a nutshell, the whole DNA. So I've been doing quite a lot of research, and I've sat on some of these DNA symposiums and webinars, and there's an upcoming one now in a couple of days on the 12th to the 14th of June, which I was invited to on behalf of Pillar 5 to attend. And it might be interesting how it has changed, because the science of paternity is forever changing, but it is legal in South Africa and we use it quite often. And we deal with it quite often, not only in criminal matters, but also in paternity matters, specifically when it comes to maintenance. And I'm quite excited to attend this DNA symposium, which is in a couple of days on the 12th, which is basically in a week's time. And I'll report back to those that have registered and would like to know more. What there might be new ways that they do testing. It might be easier ways, less invasive methods. So yes, I will definitely be reporting back on that for those that might have been interested, and how it has been evolved through the times. That brings us basically to the end of our Lunch and Learn session today. I'm Eugene Opperman. I'm a family law practitioner. I've been practicing for 23 years, specializing in mostly maintenance matters, domestic violence, and also rights pertaining to children. And this was an absolute pleasure to talk to you today and to host this webinar with regards to paternity disputes. If you have any questions, please do drop us a line on info@lunchandlearn.org.za. We are usually flooded with emails afterwards, but yes, we do get to some of those emails if and when we have time. But yes, we would love to hear from you. Love to hear your comments on social media. We have had a record number of viewers online. I see at one stage the maximum that we were with was 582 people that we had online. So thank you for that. Thank you to all the attendants, the registrants, the people that have registered. Remember to register for future webinars as well. Go to our website, www.lunchandlearn.org.za. There are a couple of webinars coming up, which is quite interesting, and which you do not want to miss. Thank you for joining us, and thank you to Erin O'Neill, our candidate attorney, for preparing the handout in this matter. And you're most welcome to drop either myself or Erin an email. And if you need to give us some comments, some feedback would be appreciated, or any questions that you might have. Thank you so much for joining us. We will see you next week, same time, same place. Have a fantastic afternoon further.